Certainly, it's a decisive moment for every single person who lives in America. American health care certainly at a crossroads. And even before Obamacare emerged here, there was big debate in this country about sustainability under the current model, or lack thereof, that we were under. So something had to be done. And obviously not everybody happy with what was done, but the court had to figure out if it would sustain itself. Now, here is what it's at the heart of the issue, of one of the many issues. And on the one side, those who believe that every American should have a plan for medical care. And on the other, those who believe that the individual mandate violated individual freedom. I'm oversimplifying, but you get the drift. Both sides entered a kind of coliseum, if you will, for a riveting showdown this week. And Andrew, obviously you, like all of us, have been following this. Break it down for us, what we learned and didn't learn over the last 3 days.
Listening to hours of the audio recordings, it's been a lot of fun.
By the way, frustrating hearing but not seeing it, but that I guess for another night.
That we'll leave that argument for another night. And we are in a crucial moment, not just for the legacy of healthcare reform, but for the election coming in November and possibly impact other types of legislation coming down the road. Now, as we stand tonight, we're left to really guess what's in the justices' minds. Whichever way the court goes, the impact, you can bet, will be widespread. Every one of us will need health care at some point in our lives, like little Lawrence Christopher Durden III.
Hey, buddy. How's it going?
The Durden family paid $25 for today's visit. Without insurance, it would have been $350. Under the Obama health care law, we all pay for each other by requiring all Americans, young and old, healthy and sick, to have insurance, and then requiring insurance companies to cover everyone no matter what. But the big question that the Supreme Court is grappling with right now is, can the government make you buy something? Conservatives on the court this week were deeply skeptical.
You can make people buy broccoli.
So can the government require you to buy a cell phone because that would facilitate responding when you need emergency services?
The other side from two liberal justices who say the uninsured still get care from the emergency room and the rest of us pay.
The people who don't participate in this market are making it much more expensive for the people who do. And the result is that everybody else's premiums get raised.
There is government compulsion in almost every economic decision because the government regulates so much.
The healthcare law does a lot more. Helps people pay for prescription drugs, coverage for pre-existing conditions. It allows young Americans to stay on their parents' health plans until they're 26. Yesterday, conservatives argued that if the requirement that everyone has insurance is struck down, all of that must go as well.
If you take the heart out of the statute's gone.
Now, no decision is expected from the justices until June, and think about the timing of that. June, just a few months before the presidential election, and Rich, we'll leave that to another day. Obviously, huge political implications of the results of this case.
And even a debate that some have argued that the best thing that could happen to the president is if, in fact, is overturned. But let's leave the politics to the side for a second. All right, joining us now to break down what went down this week at the Supreme Court, what was show and what was material, and where the justices might come down on this, Marc Fernich, criminal defense attorney and a professor at Brooklyn Law. He's argued before the Supreme Court and was named New York Metro Supreme Lawyer. And that's quite a title, by the way. All right, Mark, first of all, before we get into what happened, how much did you quake in the boots before you went before the High Court here?
I was pretty well prepared, and the advocates in this case were obviously very well prepared. You do a lot of practicing, you do mock arguments in the run-up, you've written very extensive briefs. Hopefully you've written the briefs by yourself, and nobody knows the material better than you do if you're the person who's researched it, conceived it, and written it.
But it's a totally different animal. I know moot court is moot court, but it's a little different when you got 9 justices there. They jump you in the middle of your opening statements here. When you're written this whole thing out, you get, like this guy, the Solicitor Journal, 20 seconds into it, and they're like, stop, and then they just take you off. Throw you off your game at all?
No, you're trained to expect that. The SG has argued, Solicitor General has argued before the Supreme Court many times. You want them to jump in, you know they're going to jump down your throat in 15 minutes, and you want that rather than just reading off a script to a wooden bench. And once you're into it, it's just very much like what we're doing here. It's a conversation, and it should be that way.
Now, I know you don't necessarily agree, but the consensus from the court watchers, I mean, you've seen Tubin, you've seen everybody say, Solicitor General not only had a bad day, he had an awful day. You had it handed to him, and as a consequence here, what looked to be, a couple weeks ago, every so-called expert was saying, hey, the way the Obama administration, the way they went through this, they went through all the lower courts, they got all the holdings, they basically created a paper trail that would have made it really high for the high court here to throw it out. Now they're hoping at best they'll split the baby, throw the mandate out, but at least leave something behind. What the heck happened?
I don't think anything happened. I think that this was very predictable. Jeff Toobin knows this. Cases are rarely decided in the court by oral argument. Oral argument is overrated. In 90% of Supreme Court cases, and Justice Scalia, who knows a lot better than Mr. Toobin, has written this in his book called Making Your Case, the case is decided beforehand. It's the rare bird that's swayed by oral argument. Anybody who watches the court knows that this is a highly charged political case, and it's going to be decided along ideological and partisan lines. So you're looking at a 5-4 decision in all likelihood, maybe a 6-3, with Kennedy, as usual, being the swing vote.
Do you read anything between the lines of what he asked and what he pressed? Because he certainly seemed skeptical that the Commerce Clause here was being properly applied.
And does that make a difference? Do those questions make a difference?
No,
really?
because you're playing devil's advocate. As part of my law school gig, I do moot courts all the time, and substantial moot courts, and you're just probing. And he made equivocal comments that could go both ways. I really don't know which way he's going to come out, but I will say this. Yesterday's arguments on severability, on what happens to the rest of the act if the mandate provision goes, proved that it's going to be very difficult to make a workable severability plan. And that might paradoxically strengthen the case for upholding the mandate, which is the crux of the statute.
But also from a practical level, isn't it moot because they never set aside the funding for this, because they knew politically that they would never get the money or this through Congress.
The mandate is the funding.
Right.
So if,
if the mandate goes away, there's no money.
That's the practical problem with this.
But is that something the court takes into account?
No, in a perfect world, no. In this case, this, as I've said before, this is Bush versus Gore redux. I'm a little surprised that the court took it, because whatever it does is going to be wrong and it's going to be pilloried. And as you guys remember, Bush v. Gore was a huge black eye on the court's integrity, and it's never really recovered from that. And this is going to reignite all those debates that raged after that, with the court having been accused of deciding an election.
Help Don, Andrew, and I, when we're trying to figure out the limits of the Commerce Clause, and people are saying, well, wait a second, how can you have Social Security in this country where everybody's got to get into
tax?
Right. But is that really the dividing line here, whether it's a tax or not?
This is a hybrid. I mean, this is a hybrid socialist system / private system. And that the conservative advocates and the conservative bloc on the court, if this were a pure socialist system, they would be screaming bloody murder. Yet the argument is that it's not socialist enough because you're compelling private citizens to make individual purchase decisions in the name of regulating commerce. And so you're damned if you do, damned if you don't in this case. And the commerce debate, sorry, Don.
No, and I want to ask you a question when you were done, I'm sorry.
Yeah.
The commerce debate about the scope of the Congress's commerce power is hardly a new issue, and it's not prompted by Obamacare. This has been a push and pull debate in the court since 1995. So the people who are saying that the Tea Party is behind this, do you think that Antonin Scalia needs the Tea Party to interpret the scope of the Commerce Clause for him? This has been going on for people who watch the court since 1995 in the Lopez case, and this is just the culmination of that debate.
As someone who's argued before the court, what I'm curious about, Richard, is we've watched the Jeffrey Toobins and they're reading the tea leaves and so on. Are you telling us, because I don't pay attention to that stuff.
You shouldn't.
But are you telling us that the questions from the justices, dare I say it, are they posturing for the public?
Sometimes what they're doing is trying to win other justices over to their positions. Look, there are a few things that you can safely say. Sotomayor, Kagan, and Ginsburg are going to vote to sustain the mandate. Thomas and Scalia, and in all likelihood Alito, are going to vote to knock it down. We don't know where Kennedy is going to go, and Roberts is somewhat on the fence. He doesn't want the court to look bad as the Chief Justice of the court, but really this falls on to the extent that the argument means anything, they're trying to get Kennedy to go one way or the other, and that's the way the case is going to swing.
Does a court look at the consequences to the general population? I mean, if they try and unwind this, what are they going to do? You're going to go back to a time where pre-existing conditions can all of a sudden be turned down? What happens in the interim where people all of a sudden are getting care? Are they going to lose their care? Does the court ever factor that in?
Yes, so that was the animating theme of the severability discussion on Wednesday, on the last day of the arguments. What are they going to do? In a case like this.
Did Scalia say, hey, I'm not going to read 2,000 plus pages?
You know, Scalia, well, he said, you know, that comment has been taken out of context. What that means is it's 2,700 pages dealing with fine points and minutia that are for legislators to deal with, and it's outside the court's range of competence to properly interpret all that volume of material and that degree of detail. But Scalia, you can say this for him and Thomas, normally they're ideologically consistent and the consequences be damned. Now, of course, in big cases, Bush v. Gore, there can be an exception to that. They will adhere to their ideology in this case, and also to their credit, as a criminal defense lawyer, I say this, Scalia and Thomas and that wing of the court, because of their ideological consistency, can be the defense lawyer's best friend in certain cases. So they're going to decide the case, those justices, irrespective of the consequences. But the consequences are going to weigh into Kennedy, and he's something of a pragmatist, as is Breyer, the quintessential pragmatist on the court.
They're wrapping me, but I'm going to do the question you're going to hate. What do you think happens?
I think it's a 5-4 decision, and my gut is that they will vote to overrule the mandate, and I don't know what that will be in terms of severability, but that's how I see it.
Get ready for a hot mess. Mark, thank you so much.
Anytime.
I appreciate you giving us a few minutes here.